Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where the heck am I today? Well, that is beautiful Redondo Beach, Washington, right down here in South King County. This is not far from actually where I grew up. Listen, sitting in court today, had an opportunity to read this scathing dissenting opinion, one of the funniest opinions I'd ever read, and I figured, hey, I got to get somewhere in between court dates, get this video shot, and get it out to you guys, because this really is an absolute masterpiece. What am I talking about? I'm talking about the Ninth Circuit. I'm talking about the Ninth Circuit Cabal. We're going to be talking about today, of course, a case in which the plaintiff was successful before the three-judge panel, only to have the Ninth Circuit en banc panel swoop in, as they usually do, and take it over. So today, from Redondo Beach, Washington, let's spend a couple minutes and talk about when the Ninth Circuit gets so bad, it starts calling itself out. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, America, this is what we're talking about today. We're talking about a case which we have talked about before. It is the case of United States v. Duarte. This is a challenge to 18 United States Code Section 922G1, which we all know is the statute that disarms all felons, and in many instances disarms felons for the rest of their life, and that includes all non-violent felons. Now, Mr. Duarte had, of course, prevailed before the three-judge panel, who found that there was no historical analog to justify the statute's constitutionality. But now the Ninth Circuit has swooped in, vacated the order, and will take the matter en banc. Now, this has Justice Van Dyke of the Ninth Circuit pretty ticked off, and he has written this scathing dissenting opinion, which I'm going to share with you. I'm going to share with you kind of the first part because it really is the most entertaining part. But as I said, when the Ninth Circuit gets so ridiculous that you have justices within the Ninth Circuit calling it out, well, you know that things have gotten way, way out of hand. What would you do if you were stuck in one place and every day was exactly the same and nothing that you did mattered? In the Ninth Circuit, if a panel upholds a party's Second Amendment rights, it follows automatically that the case will be taken en banc. This case bends to that law. I continue to dissent from this court's Groundhog Day approach to the Second Amendment. Oh, but you see, Justice Van Dyke, he's just getting warmed up because he continues to argue. The Supreme Court's docket this next term is no doubt full of important issues to decide, and this delay the inevitable approach to pressing Second Amendment questions would be just fine if the circuit courts were populated with judges committed to faithfully applying the considerable instruction already provided to us by the court. But that is clearly not the case. In this circuit, you could say that roughly 2/5 of our judges are interested in faithfully applying the totality of the Supreme Court's Second Amendment precedent when analyzing new issues that have not yet been directly addressed by the court. The other 17/29 of our bench is doing its best to avoid the court's guidance and subvert its approach to the Second Amendment. That is patently obvious to anyone paying attention. To say it out loud is shocking only because judges rarely say such things out loud. And that is the absolute truth. Very rarely will you see a justice call out the entire procedural mechanisms under which the court is operating under. Obviously, you'll see justices be critical of the other side's opinions, but this is an attack on the entire structural mechanisms by which the Ninth Circuit has been operating now for decades. For most judges in our circuit, any loss in a Second Amendment challenge at the Supreme Court is celebrated as a tool to further our artificial cabining of Bruin. And that too is so true because there is no circuit in America that more roots for gun owners to lose than the Ninth Circuit. They almost relish in a Second Amendment loss. And as the Justice points out here, such losses are bound to arise as with any constitutional challenge. Not all Second Amendment ones have merit. But when those losses occur, our court will grasp onto the loss itself as if it were the overreaching guiding principle offered by the court, using it to supplement and invigorate the cherry-picked language already mis- and over-applied from the court's prior precedents. Like some judges who eisegete scripture just to validate their pre-existing worldview, judges who are more interested in sidestepping than following the court's Second Amendment precedent will latch on to phrases like presumptively lawful and law-abiding citizen while conveniently overlooking such bothersome details like the government's burden of supplying relevantly similar historical analogs. And what the judge is getting at here is that this playbook that the Ninth Circuit uses over and over and over, it's getting old, but it's also quite predictable. None of our current justices spent time in this circuit, so perhaps it is understandable that they would reasonably expect all lower courts to faithfully apply the entirety of their Second Amendment case law. Let's be clear, out here on the left coast, that is a fantasy. I mean, this really sounds like language that I would use on this channel, so it is obvious that Justice Van Dyke has had it up to about here with the shenanigans of the Ninth Circuit, but he doesn't stop there. The Ninth Circuit is going to joyride Rahimi and the GVRs that followed it like a stolen Trans Am until the Supreme Court eventually corrects us again. And as you guys know, I did this video right here, and then I also did this video right here where I'm like, hey, listen, I get that Rahimi is a real narrow ruling, but if you take a look at all of the language, there is nothing narrow about how it's going to be used against us. And Justice Van Dyke begins to point that out here as well. Emboldened by Rahimi's loss and the court's subsequent GVRs, the en banc panel in this case will surely rely on Rahimi as support for the inevitable and entirely predictable conclusion that Duarte has no Second Amendment rights. Now, if you want to know the rule of law upon which Justice Van Dyke believes that the en banc acceptance of this issue is improper, he summarizes it as follows. Applying the reasoning in Rahimi led the court to conclude that Rahimi could be disarmed under Section 922G8. But applying it here leads to the opposite conclusion about Section 922G1 as applied to Duarte. The government failed to show that the underlying crimes Duarte committed were analogous to any category of crime for which death, a state forfeiture, or a life sentence was the historical penalty. Under the reasoning of Rahimi, therefore, the core logic of Duarte was validated, notwithstanding the different outcome in the two cases. But ultimately, in the final coup de grace from Justice Van Dyke, and which really sums up what this entire dissent is about, he closes it with the following. In a circuit with a majority of judges committed to faithfully applying the Supreme Court's Second Amendment jurisprudence, I wouldn't need to write this. In that world, this court's forthcoming en banc decision denying Duarte's Second Amendment rights could be characterized as additional desirable lower court percolation that might possibly assist the Supreme Court when it eventually addresses this question. But precisely because a supermajority of our court is so predictably biased against firearms, our en banc decision will once again speak volumes only about Second Amendment inevitability in the Ninth Circuit, while telling us nothing about how the Supreme Court's precedents, properly construed, apply to Section 922G1's ban. Maybe someday we will break out of this predetermined script. Okay, this certainly is one of the most scathing indictments ever written about the Ninth Circuit, and of course it comes from a Ninth Circuit justice. Kudos to Justice Van Dyke for saying what's been on a lot of our minds for quite some time. Okay, the case once again is United States of America v. Duarte. We're going to link it up down below so that you can read Justice Van Dyke's absolutely awesome dissenting opinion, and you will find it thoroughly entertaining. Maybe you got questions about this or anything else related to what's left of our Second Amendment rights. You guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. Maybe you got an idea for a video we should be doing. If you do, go ahead and click on that link right there, because really most of the good ideas we come up with aren't our ideas at all. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From beautiful Redondo Beach, Washington, thanks for watching. Stay safe.